There's a lot of spin circulating about the voice referendum and about the proposed Indigenous voice. So let's look at some of the most commonly circulated myths and debunk some of the claims. And if you think I've missed anything, well, definitely do let me know that in the comments below. And much of this information is in fact coming from Warren Mundine and Jacinta Price in a book that Warren Mundine put together, which I'll link to in the description below. It's well worth the read. The first myth is that the voice is merely advisory. The Yes camp likes to assert that the voice is just an advisory body. It can merely put forth a perspective which the executive or the parliament might then listen to if it chooses, or they could ignore it if they choose. They could go in a different direction if they don't agree with the voice and its representations, or they might decide to go along with the voice. It's really up to them. However, that analysis would be rather superficial. The voice actually has more funding and access than any other body. This alone makes it much more powerful than any other individual or many of the other lobby groups circling around, which need to go out and raise their own money and don't have the benefit of the taxpayer. So let's consider this in the context of the Western Australian cultural heritage laws. Suppose those laws resurface at the federal level. Well, then the Indigenous voice could make representations on it. Presumably, they would be in favour of the cultural heritage laws. However, there's no body for the farmers or for the landholders. Therefore, no one else has the same access as the voice, and therefore they can be steamrolled. This is rather akin to the situation where you've got a court case. Say, for example, you fund and listen to only one side of the court case, and the other side is simply silent and is left out in the cold. Now, that one side that has funding and access, well, they're merely advising the judge, they're merely making representations. However, the outcome is a foregone conclusion. It's pretty obvious that this is hardly even-handed. The voice also could credibly threaten to sue if it doesn't get its way. This is a function of basic administrative law, basic legal doctrines. This basically asserts that whenever an executive member, a government administrator, makes a decision, they need to consider all relevant information and they must not consider irrelevant information. The mere fact that the referendum is creating this voice body has deemed the voice to be relevant. Therefore, the referendum will basically deem the executive to have to listen to the voice's representations. It might actually get a little bit worse than this, because it might be that the administrators then need to go to the voice and inform them they're about to make a decision, so the voice can then make representations. However, that is to be determined. But in any case, suppose the voice doesn't get its way. Well, then it might allege that the government has simply ignored it. It didn't consider its representations. It could then threaten to sue. It can do this because it has very deep pockets funded by the taxpayer, and they don't lose anything from launching a frivolous lawsuit. However, individual bureaucrats do in fact lose from a frivolous lawsuit because then they need to go through the stress and the travail and the time and the money perhaps of appearing in court. The administrators would then be cowed into submission. The administrators clearly wouldn't want to have to go into litigation with the voice, and therefore the voice can simply threaten to sue and get its way. This in practice is another way that the voice could wield power. Now, this isn't to say it will necessarily happen for certain, but absolutely it's a tool in the toolbox that the voice could wield, and it gives it actual real power, and it is not merely advisory. The next myth is that treaty and reparations are irrelevant. Anthony Albanese and Mark Dreyfus and the rest of the Labour Party have asserted that talking about reparations and treaty is a scare campaign. They say that it's a lie to link the two. It's a lie to link the voice with reparations or with treaty. However, they are completely and manifestly wrong. And Anthony Albanese is simply misleading people. He is gaslighting. Treaty and reparations are entirely relevant, and they are manifestly on the ballot. This is because Anthony Albanese has committed to the Uluru Statement in full. Further, the voice is simply the first step toward a treaty. It's right to ask what a treaty would involve and what it would be about, whether there might be a financial settlement or reparations as part of that treaty. Well, it obviously could include that, because that's in the background documents underlying the Uluru Statement. And you don't need to take my word for it. You can look at, like I said, the background documents to the Uluru Statement, but also statements from prominent Yes campaigners and members of the Uluru Dialogues, which gave rise to the Uluru Statement and gave rise to the voice. For example, we can look at what Uluru Dialogue co-chair Megan Davis had said in an article. She penned an article with George Williams, another constitutional law academic. They detailed how voice would in fact lead to treaty and how it would be a structural quote-unquote reform. The article is literally titled, "Without the Indigenous voice to Parliament, a treaty is vulnerable." The article literally says in the title that voice would be key to getting treaty. Therefore, it is entirely appropriate to draw the linkage between voice and treaty, and therefore presumably reparations, because that presumably is what would be in a treaty. Or we can listen to other campaigners such as Thomas Mayo. Now, Thomas Mayo is not in the government, and he might not even be a voice representative if the voice ultimately gets up. However, his comments give us a clear idea of what the voice aims to achieve.
This is the first step. It's a vital step, and it puts all the explanation behind it. Pay the rent, for example. How do we do that in a way that is transparent and that it actually sees reparations and compensation to Aboriginal and Torres Strait Islander people?
The power in the voice, campaign for that, and punish politicians that ignore our advice. That is where the power comes from.
It is very clear, therefore, that the voice will increase the likelihood of a treaty, and with treaty, the likelihood of reparations or compensation or a financial settlement or whatever term we want to use. Therefore, it is very appropriate to draw the linkage between the voice and reparations, regardless of what Anthony Albanese says. Now, it is worth addressing a couple of misconceptions surrounding the voice and treaty. First, it's sometimes claimed that treaties can exist without the voice, and therefore it is inaccurate to link the voice to treaties. However, that completely ignores probabilities. A treaty with whole-scale reparations is more likely if the voice gets up. It is possible if there is no voice, but it is more likely, more probable if there is a voice. Therefore, if you want to reduce the probability of a treaty and with it a financial settlement, you would vote against the voice. It is completely irrelevant that a treaty could exist even without the voice. What is of relevance is what is the likelihood of a treaty, conditional on whether there's a voice or not. Second, Warren Mundine created a little bit of confusion by suggesting that treaties could come if the voice doesn't succeed. In addition to what I already said, what Warren Mundine was getting at here is the idea of land use rights. That is, royalties that can exist when land is used, land that is used and owned by those traditional owners. Those land use agreements have existed for a very long time. Warren Mundine was pointing toward those existing land use agreements rather than additional treaties with additional financial compensation, which is something he specifically clarified after he made his slightly confusing statements. So overall, therefore, it is very clear that the voice will increase the likelihood of a treaty, and with it, a greater likelihood of a financial settlement, or compensation, or reparations, or whichever term you want to use. The third myth is that the voice can only talk about Indigenous matters. Anthony Albanese does in fact like to claim this. He likes to claim that the Parliament could limit the remit of the voice. However, this is an obvious simplification at best. The Parliament simply won't be able to limit the voice after the referendum. The text of the proposed wording itself says that the Indigenous voice would be able to make representations on matters that affect Indigenous Australians. Not matters that differentially or directly or unusually affect Indigenous Australians, just matters that affect them, which is basically everything. Furthermore, the Parliament's powers are subject to the Constitution. So if the Constitution then says that the voice can make representations on any matter impacting Indigenous Australians, Parliament cannot then go and limit it to certain circumstances or to specific matters. Parliament would be hamstrung by the very wording in the Constitution. And therefore the voice would not merely talk about Indigenous matters, it would talk about matters more broadly. So in theory it could make representations to the RBA, or on climate change, or on farmland, or myriad other things. Now, Malcolm Turnbull has actually asserted that they could do this, but they never would. However, I'm not entirely sure what makes Malcolm Turnbull so convinced. But in any case, it is very clear that the voice could have a very broad remit. The next myth is that details are irrelevant, and you don't need to ask about these, and if you're asking about them, then you're simply obfuscating and getting in the way. The Yes Camp likes to point to vague terms in the Constitution. They like to argue that the fact that Section 51, for example, is vague, that's a justification for yet another vague term. This logic, however, is wrong. Firstly, if voters actually want the details, well then they're entitled to details. If you need to convince someone to do something and they say, well, you can convince me if you give me details and convince me the details are good, well, then you have to provide those details. You can't just say, well, I don't think you should have them. That's clearly not going to win the day. So these details are relevant because voters say they are relevant. But that notwithstanding, given that Anthony Albanese has made many claims that the voice could be limited in scope, people are entitled to put this to the test and to demand proof. They are entitled to see the details that would limit the voice, because it doesn't appear that the voice could be limited, but if he thinks it can be, well, he needs to put up or shut up. It's very clear that people simply don't believe him. This is especially the case since Anthony Albanese opted for a referendum that was cast in the broadest, most activist terms possible, rather than a narrower one that perhaps would limit the scope of the voice, limit its ambit, and limit its powers. Anthony Albanese brought this whole situation on himself by having such broad terms, and then exacerbated it by refusing to provide additional details or additional legislation that might ultimately be what empowers the voice if the voice referendum were to succeed. And not only that, say we look at the other vague parts of the Constitution, well then in fact we might actually want more constraints, and we might want more details. If we look for example at the war power, it's clearly open to abuse. The fact that existing powers can be abused is not a good reason to create yet another one. The next myth is that the voice is about representation. Anthony Albanese likes to assert that the voice is just a way to have Indigenous representation in the Constitution. It's just a gracious gesture. It's a gracious offer coming from Indigenous Australians. The referendum question itself is phrased slightly misleadingly to make it look exactly as such. The referendum question states, a proposed law to alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Do you approve this proposed alteration? That question itself is actually rather misleadingly phrased. It puts the recognition at the front, and it buries the voice itself. It buries the powers the voice would have. It makes the voice look as if it is merely recognition. But it clearly isn't, given the powers that I've already talked about. It's making it look like the voice is just there to recognise Indigenous Australians, when in fact it goes much further. Also, if we look at the proposed chapter to the Constitution, it's titled, In Recognition of Aboriginal and Torres Strait Islander Peoples as the First Peoples of Australia, we would establish the voice and so on and so on and so on. Again, it's asserting that this is about recognition. It is clearly not about recognition, because as I've indicated, the voice would have power, and it could push for treaty and for compensation or financial settlement or reparations, or whatever we want to call it. This is not just about recognition. As I've highlighted before, the voice would have real power. Megan Davis and George Williams have called this a structural reform. It can't be both a structural reform and just about recognition. The two aren't compatible, and as I've indicated, it is about power. It's also worth highlighting that Indigenous Australians make up about 3% of the population, but at the moment, about 5% of federal MPs are in fact Indigenous, and Indigenous Australians can also vote and have the same rights as all of the other Australians. So therefore there is already recognition, and therefore this referendum is not exactly necessary for a voice to exist, because there is already a voice. And in any case, those are some of the top most circulated myths about the voice referendum. If you've got any thoughts about this, well, let me know that in the comments below. If you think I've missed anything, also let me know that as well. I'd be interested to hear your thoughts about what the top myths happen to be. But otherwise, thanks a lot for tuning in. Don't forget to subscribe, and hopefully I see you next time as well.